challenging the notice dated 12/12/2024 sent by the 23 लॉर्डशिप। घर गिराने का नोटिस लॉर्डशिप हमको पेज 8 पे सीधे वही नोटिस है, बाकी कोई प्रोसीजर हमको पता भी नहीं, हमको नोटिस भी नहीं आई है। सीधा पेज 8 पे नोटिस आया है कि हटा लें 15 दिन के अंदर।
सेक्शन 309 देखिए
लॉर्डशिप वो मैंने कोट किया है लॉर्डशिप, पेज 4 ऑफ माय पिटीशन
309 ऑफ द म्युनिसिपल कॉर्पोरेशन एक्ट।
लॉर्डशिप
उन्होंने क्या नोटिस दिए?
सीधा हटाने का नोटिस, पूरे घर को हटाना है 15 दिन के अंदर।
यस मिस्टर,
they have not given us any objection or representation directly.
ये तो आप नोटिस दीजिए ना उनको।
वही
Lordship, then we'll provide them with the opportunity of hearing as per the provision of section 309 clause.
इसमें तो आप सीधा बोल दिए उनको
सीधा
कि आप वो हटा लेवे।
As per the inspection.
बट 309 से कि unless and until you provide a notice,
Provision में है।
हाँ 309
309
पेज 5 पे है, सॉरी।
calling upon the occupier or owner to state in writing his objection to such prohibition within 30 days from the receipt of the notice. अच्छा, आपको देना पड़ेगा डिटेल। इसमें लिखिए by the present petition the petitioner is questioning the notice। ऊपर में नोटिस लिखे हैं but the language is not
लैंग्वेज नॉट
dated 12/12/2024 by which a notice under section 309 has been issued to the petitioner to क्या हटा लेवे इसमें?
पूरा घर है लॉर्डशिप, भवन हमारा घर, उसके लिए
15 दिवस के भीतर हटा
लॉक
लेवे लिखा है।
जी डिमोलिश करने के लिए।
Directed the petitioner to remove or dismantle the क्या हाउस है ये? House situated in ward number 38 भातखंडे संगीत महाविद्यालय बिलासपुर, stating that the property in question is in a bad condition and any mishap could be take place. Learned counsel for the petitioner submit that though the notice annex P1 has been designed as per section 309 of the Municipal Corporation 1956, however, the contents of the notice is not a notice. The same is to remove the house in question from the to dismantle the house in question. Learned counsel for the petitioner by referring the provision of section 3091 submits that if it appears to the commissioner that any building intended or used for human habitation or human occupation for any purpose whatsoever is unfit for such habitation or occupation, he shall give notice in writing to the occupier or to the owner, if the building is not occupied, stating that the building is unfit and signifying his intention to prohibit the further use of such building for such purposes, and calling upon the occupier or owner to state in writing his objection to such prohibition within 30 days from the receipt of the notice, and if no objection is stated by such occupier or owner within the said period, or if the objection stated appears to the commissioner to be insufficient or not well founded, he may, with the previous approval of the mayor in council, prohibit by an order in writing the further use of such building for human habitation or occupation, and shall affix a notice to that effect on a conspicuous part of such building. In the present case, no such compliance has been made and no notice of 30 days representation or objection has been made to the petitioner. Hence, the order, hence the notice as not in accordance with law deserves to be quashed. Learned Counsel for the Municipal Corporation submits that the impugned notice is after inspection made by the municipal corporation, and as the house in question is not in a bad condition, the notices has been issued on 12/12/2024, but without filing any objection or representation to the said, the petitioner has preferred the writ petition, which is not maintainable at this stage. I have heard both the parties and peruse the notice as well as the provision of section 309. Full point. From perusal of section 309, it is very clear that the petitioner is entitled for a notice before taking action under section 310 of the Municipal Corporation Act. However, though the notice is framed as under section 309, but the content of notice shows that the petitioner has been directed to remove or dismantle the house standing over the land. Hence, the notice annexure P1 12/12/2024, which is not in accordance with this provision of section 309, is quashed. However, liberty is reserved for the corporation to issue a proper notice under section 309, and the corporation is liberty to pass appropriate order in accordance with the provision of section 309 and 3010 of the Corporation Act 1956.
Oh, bless.
Disposed of.
Okay.
Item 24, Sri Aniruddha Sri